Have you ever felt the ground shake beneath your feet, only to realize it wasn't an earthquake, but the rumble of government defiance? That's exactly what's happening right now in Florida. The Sunshine State has become the epicenter of a political and constitutional aftershock. What we're witnessing isn't just bureaucratic confusion. It's open rebellion against the Second Amendment itself. Let's rewind the clock. Since 1987, Florida has maintained one of the most oppressive bans on open carry in the nation. For nearly 40 years, law-abiding citizens were treated like criminals for doing nothing more than carrying their own lawfully owned private property in plain sight. Imagine that. Citizens who passed background checks, paid taxes, followed the law, and still faced arrest for showing a holstered sidearm on their hip. That's not freedom. That's government overreach disguised as public safety. But everything changed on September 10, 2025, when the First District Court of Appeal finally drew a line in the sand with the historic ruling in McDaniels versus State of Florida. This was no minor technical decision. This was a 7.8 on the constitutional Richter scale. The court didn't just speak, it roared. And what it said was clear. Florida's total ban on open carry violated the United States Constitution. The court's foundation rested firmly on the Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruin, the Bruin case that rocked the entire country. That landmark ruling established one unshakable principle. Any firearm restriction must align with America's historical tradition of gun regulation. No modern political talking points, no vague claims of public fear, just hard, historical evidence. Florida couldn't meet that burden. The court found that the state had zero justification, past or present, to ban law-abiding adults from carrying a firearm openly in public. And in that moment, a decades-old law, Section 790.053 of the Florida statutes, was declared unconstitutional. The open carry prohibition was gone, obliterated. 5 days later, the legal explosion rippled outward when Attorney General James Youthmayer issued a formal memorandum on September 15, 2025. His message was unambiguous. Open carry is now lawful in Florida. Period. He instructed every law enforcement officer, every prosecutor, every trial court, stop arresting people for exercising a constitutional right. This wasn't a polite suggestion. It was a directive grounded in law and backed by the full authority of the state's top legal office. Before this momentous shift, the penalties for open carry were absurdly harsh. A second-degree misdemeanor, up to 60 days in jail, a $500 fine. The only exceptions were comically narrow. If you were hunting, fishing, or camping, or if the firearm was briefly visible but not angry or threatening. That's right. Florida law literally used the word briefly. But on September 25th, 2025, everything flipped. That date now stands as a milestone in American gun rights history. From that day forward, any eligible adult who could legally possess a firearm gained the right to carry it openly. No more hiding, no more criminal penalties for visibility. Yet even as the ink dried on this groundbreaking victory, something sinister began to take shape behind the scenes. Certain state officials, sworn to uphold both the United States and Florida constitutions, decided to defy the courts and the Attorney General. They refused to recognize the ruling. They sowed confusion. They sent mixed messages to local police. And in doing so, they endangered every responsible gun owner in the state. This isn't caution. It's deliberate obstruction. It's government acting like a spoiled child caught in the act, stamping its feet instead of following the law. These politicians aren't just playing games with policy. They're playing games with your liberty. And this is where the story takes a dark turn. Because the very people charged with enforcing the law have now become its greatest violators. The battle lines are drawn. Florida is entering a new kind of conflict, one that pits sheriffs against the Constitution itself. The battle lines are drawn, and the front is inside Florida's own law enforcement ranks. Picture this. The Attorney General has just declared open carry legal. The courts have spoken. The people have celebrated. But on the ground, confusion, rebellion, and defiance. What should have been a moment of clarity turned into a battlefield of conflicting authority. The problem lies in Florida's layered court system. The McDaniels versus state ruling came from the First District Court of Appeal, which covers only part of the state. But the Attorney General insisted the ruling applied everywhere, that it was binding on every trial court, from the Panhandle to Miami-Dade. In theory, that meant the law was clear. In practice, it was anything but, because Florida has a conflicting precedent. The 2017 case Norman v. State, where the Florida Supreme Court upheld the very same open carry ban the McDaniels court just struck down. So now the state stands in a constitutional standoff. Two courts, two rulings, one law that's both dead and alive at the same time. And until the Florida Supreme Court steps in again to resolve it, citizens are stuck walking a legal tightrope, armed, cautious, and uncertain. But the real firestorm? It's not in the courtroom. It's in the sheriff's office. Across multiple counties, elected sheriffs, constitutional officers sworn to defend both the United States Constitution and the Florida Constitution, are openly defying the Attorney General's directive. They're saying, we're still going to enforce the ban. Think about that for a moment. A court has declared the law unconstitutional. The Attorney General has affirmed it. Yet some sheriffs are saying they'll keep arresting people for exercising their rights. That's not law enforcement. That's insubordination against the very foundations of constitutional authority. Their reasoning? They claim they're protecting themselves. They argue that because Section 790.053 technically remains written in the statutes, despite being struck down, they could face audits, lawsuits, or accusations of dereliction of duty if they stop making arrests. In other words, they'd rather violate your rights than risk bureaucratic backlash. Let's call that what it is: cowardice wrapped in paperwork. Their primary duty is to the Constitution, not to a line of outdated ink in a statute book. When a court of competent jurisdiction declares a law unconstitutional, that law is void. Period. Any officer who enforces it after that ruling isn't protecting the public. They're violating it. And make no mistake, this isn't just a political debate. It's a ticking legal time bomb. Every arrest made under that defunct statute opens the door for massive civil lawsuits. Every detained citizen becomes a potential plaintiff. Every county that continues enforcement is gambling with taxpayer money. And the people of Florida will be the ones footing the bill for unconstitutional arrests. Meanwhile, responsible gun owners are the ones left standing in the crossfire. You could cross from Leon County, where local officials respect the McDaniels ruling, into Orange County, where the sheriff still clings to the old law, and suddenly find yourself under arrest for something perfectly legal just a few miles back. This is the chaos born from defiance. The law changes at the county line, not because the Constitution says so, but because a local official decided he knows better than the courts. And here's the cruel twist. Until the Florida Supreme Court takes up McDaniels, or the state legislature repeals the dead law, this nightmare continues. You, the citizen, are left in limbo. The same government that demands obedience is now refusing to obey itself. But even in this storm, there are constants. Rules that every firearms enthusiast must understand. The McDaniels ruling restored the right to open carry, but it didn't create anarchy. It didn't erase all limits. There are still no-go zones, legally designated areas where your right to carry ends at the door. Under Section 790.0612A, open carry is prohibited in specific sensitive locations: police stations, jails, courthouses, polling places, and legislative meetings. Schools remain off-limits, every elementary, secondary, and college facility, except for one narrow exception. A registered student, faculty member, or employee may carry a non-lethal stun gun. Airports? Off-limits. Bars primarily serving alcohol? Off-limits. It's a maze that demands vigilance. These zones aren't arbitrary. They're the battleground for the next phase of this legal war. Because every single one of these restrictions will have to survive the Bruin test, the historical tradition test that requires the government to prove that similar restrictions existed at the founding of the Republic. And that, my friends, is a tall order. Even the Attorney General was explicit. Open carry is not a license for intimidation. Under Section 790.10, displaying a firearm in a rude, careless, angry, or threatening manner is still a crime. You must carry responsibly, confidently, but never recklessly. Florida's gun owners are now living through a constitutional test in real time. The courts drew the line. The politicians erased it. And the sheriffs? Some chose to stand on the wrong side of history. The question now is simple. Who will blink first, the government or the people? When sheriffs become the law instead of enforcing it, you don't have justice. You have chaos wearing a badge. And right now, that's what's unfolding in Florida. Let's step back for a second. The Attorney General's directive wasn't a suggestion. It was a formal legal opinion based on a binding appellate ruling, the kind of document law enforcement is supposed to follow unless overturned by a higher court. But instead of compliance, some sheriffs issued their own public statements saying, in effect, "We're going to keep doing it our way." Translation: they're substituting personal opinion for constitutional law. That's not bravery. That's bureaucratic mutiny. And make no mistake, it's dangerous. Because once officers decide they can pick and choose which court orders to follow, the entire concept of rule of law starts to collapse. Imagine this in any other context. What if tax collectors refused to follow a Supreme Court ruling on income tax? What if local officials ignored a federal court order on free speech? What if a sheriff decided to interpret Miranda rights differently? We'd call that an abuse of power. But when it comes to gun rights, too many people look the other way. Here's what's really happening. These sheriffs are using fear of liability as cover for political theater. They say, "We might get sued if we stop enforcing the ban." But here's the truth. They'll get sued either way. The only difference is who's suing: a bureaucrat with a clipboard or a citizen whose rights were violated. And history shows the court side with the citizen. Every sheriff swears an oath to uphold the U.S. Constitution and the Florida Constitution, not the personal opinions of a city attorney or the ghost of an outdated statute. The McDaniels decision didn't just strike down a line of text, it reaffirmed a principle: that no state government can criminalize a constitutional right simply because it makes politicians uncomfortable. And if you want to see where this road leads, just look at California or New York, two states that spent years defying Bruin, writing emergency laws that rebranded gun-free zones and dared the courts to stop them. Guess what? They lost, over and over again. And now Florida is walking that same path, only this time it's not blue state legislators doing the damage, it's their own sheriffs. But there's a twist that makes this story uniquely Floridian. Because here, the people don't just grumble, they organize. Gun owners across the state have begun documenting every unlawful arrest under the old statute, preparing coordinated civil rights lawsuits under Title 42, Section 1983, which allows citizens to sue state officials for constitutional violations. Lawyers are stepping up. Advocacy groups are mobilizing. And some county commissioners are quietly warning their sheriffs, if you keep enforcing this, you're going to bankrupt your department. In short, the reckoning is coming. It won't arrive with flashing lights or courtroom drama. It'll come quietly, case by case, as judges across the state rule that citizens' rights were violated and order those counties to pay. That's how revolutions start in the modern age. Not with a musket, but with a lawsuit. But let's be clear, this isn't about anti-police sentiment. Florida has some of the best deputies and officers in the nation. Many of them want to follow the Constitution. They're caught between orders from above and principles they swore to uphold. It's not the rank-and-file deputy that's the problem. It's the leadership using their badge as a political shield. And here's where it gets ironic. While sheriffs are defying open carry rights, their own deputies are exempt from most of those restrictions. The same men telling citizens, "You can't do that," are doing it every day on duty, safely and responsibly. That hypocrisy isn't sustainable. The people of Florida understand that the right to bear arms is not a suggestion. It's not a loophole. It's not something granted by permission. It's something protected by principle. And if those in power forget that, they'll be reminded in the same way every tyrant throughout history has been reminded, by the citizens they underestimated. But before that day comes, there's one more piece of the puzzle. One that explains why this fight matters, not just to Florida, but to every state in America. Because what's happening in the Sunshine State isn't just a local dispute. It's the test case for the future of gun rights in the entire nation. Every major constitutional battle starts in one state. A spark in a courtroom becomes a flame in the legislature. And if it burns hot enough, it spreads nationwide. That's exactly what's happening right now in Florida. Because make no mistake, McDaniels versus state isn't just about open carry in one state. It's about whether lower courts can use the Bruin decision as a sword instead of a shield, cutting through unconstitutional laws even before the Supreme Court steps in. And if Florida's appellate ruling stands, it could ripple through Texas, Georgia, Virginia, and beyond, forcing every state still clinging to old bans to face the same constitutional reality. Let's break it down. The Bruin framework, established by the U.S. Supreme Court in 2022, did something revolutionary. It flipped the burden of proof. Before Bruin, citizens had to prove why they needed a firearm. After Bruin, the government now has to prove why it has the authority to restrict one, using historical tradition as evidence. That means no more arbitrary bans, no more public safety excuses, no more modern inventions dressed up as law. When Judge McDaniels applied that framework to Florida's open carry statute, she found something the state couldn't hide. There was no historical tradition at the time of the founding that criminalized the peaceful carrying of arms. None. The very concept of open carry prohibition would have been unthinkable to the framers of the Second Amendment. That precedent doesn't stop at Florida's borders. It's a legal blueprint, and lawyers in other states are already studying it, because the same argument can strike down restrictions in Maryland, where open carry still triggers law enforcement suspicion. It can dismantle parts of Illinois' dense web of transport restrictions. It can even challenge the infamous may issue policies that blue states keep rebranding under new names. And here's the irony. The more these states resist, the stronger the constitutional challenge becomes. Every defiant statement, every unlawful arrest, every temporary emergency law only adds fuel to the fire. But there's a deeper current under this, something philosophical. The Second Amendment debate has never really been about guns. It's been about trust. Can the people be trusted with the same rights their government claims for itself? Do citizens deserve the same tools for defense that the state uses to protect its own buildings? The answer in Florida, at least for now, is yes. The Attorney General recognized it, the courts affirmed it, and the people are standing on it. But what happens when one state reasserts that right so strongly that it forces others to follow? That's when you get a national cascade. Just like Heller reshaped the handgun debate in 2008, and Bruin reshaped concealed carry in 2022, McDaniels could be the case that finally tears down the last wall, the arbitrary line between concealed and open carry. Because think about it, if the Constitution protects the right to bear arms, that includes carrying them in public. And if the government can't prove a historical reason to stop it, then every modern ban is already on borrowed time. This is why Florida's defiant sheriffs, the confused citizens, and the silent legislature are all standing in a moment that will be remembered for decades. Their choices, to comply, to defy, or to delay, will shape how courts interpret the Second Amendment for the next generation. And for those watching from outside the state, don't think this is just another headline. What happens here determines whether your state will keep its bans or whether your local open carry law will crumble the same way. Because constitutional rights don't stop at the state line. They echo, they spread, they evolve through courage, and they survive through conflict. And if Florida finishes this fight the right way, through courts, through legislation, through citizen persistence, it won't just be restoring one state's freedom. It'll be restoring the balance between government and governed across the entire republic. But before we close, there's one last chapter. The part where this all comes together, where the courts, the sheriffs, and the people collide in a single defining moment.